Good afternoon, everybody. My name is Maria Williams, and I'm the Housing Program Manager at the Pennsylvania Coalition Against Domestic Violence. And I am here today with my colleagues, Danny Petio also from PCADV. She's the senior attorney there, and the Director of Public Policy, Larissa Kaufman from the National Alliance for Safe Housing. This workshop today is presented in partnership between PCADV and the National Alliance for Safe Housing. NASH is our federal partner, helping with everything from policy development to on the ground everyday work, and works in conjunction with a number of other federal partners to make sure that domestic violence is prioritized and accounted for with federal funders and others as we continue to develop needs for survivors. So thank you all so much for attending today, and we're hoping to talk more about just the basic domestic violence and housing needs. I know that many folks have that information, but we want to make sure that we're all using the same framework when we're talking today. And then the meat of the presentation is going to be given to you by Larissa and Danny. And Larissa and Danny, both as attorneys, have a deep understanding of the Violence Against Women Act and how that actually plays out in housing scenarios, what protections exist for survivors, and how Pennsylvania has taken bits and pieces of VAWA and translated it to the state level to make sure that that exists here too. They're going to help you understand how to apply the housing protections. We'll also talk about emergency transfers, and I'll speak a little bit about how that's played out, particularly in the balance of state here in Pennsylvania, and then talk about any national, state, and local resources. As we're going today, if you can please ask questions in the chat as you've been instructed to, that would be great. I'll be fielding those questions as they come in, and then we'll answer them at the end. If there is something that is contextual to what we're talking about and really would move things forward with the presentation, I'll be sure to bring that up as we go. But otherwise, we'll be taking questions and discussing things at the end. So please do feel free to ask questions. It's far more informative for us and will be far more informative for your colleagues if your questions are really being answered through this process rather than us just giving you a bunch of information. This is a really content heavy PowerPoint. The reason is that we're not in person. And so we want to make sure that today you're walking away with actual paper that you can refer back to. The laws are really broken down throughout this PowerPoint in a way that should be really helpful to everyone from housing providers to landlords to case managers, and should really help you answer your questions almost on a day-to-day basis. Also knowing that you please feel free to reach out to PCADV anytime. I'm always happy to provide technical assistance to any housing provider or landlord in Pennsylvania. So what is domestic violence? According to the PCADV website, we define domestic violence as a pattern of coercive behavior used by one person to gain power and control over another in an intimate or familial relationship. We've been talking a lot about the differences between intimate and familial relationships and who provides what services and that sort of thing. And so this is an important thing to know, is that domestic violence does include both, but some domestic violence organizations only serve folks that are experiencing intimate partner violence. Some domestic violence organizations serve folks that are experiencing both intimate partner and familial violence. So that's an important thing, important context to have. Many terms, though, are used interchangeably to describe domestic violence: intimate partner violence, abuse, domestic abuse, battery, family spousal relationship, dating violence, all these sort of things. That all, those are words that we use interchangeably for domestic violence. We'll be referring to it as either domestic violence, sexual assault, and intimate partner violence are the terms that we use the most. And so know that when we say those, we mean a lot of different things, right? And whatever word that you use is fine. One of the best ways to know what word to use is to listen to the survivor that you are working with, and however they refer to the experience that they've had, that's the words I would return to them to make sure that their situation is normalized. So we know that domestic violence is prevalent and present in every community and every location across Pennsylvania. The CDC says that 1 in 4 women and 1 in 7 men have experienced physical abuse from an abusive intimate partner. This is probably actually an underreport because we know that many cases of domestic violence go completely unreported. So it's hard to know how prevalent domestic violence is, but if this is the baseline, we know that it happens in all of our communities. DV can be characterized as many different sorts of things. I think that for those of you that have been in trainings with PCADV before, we often talk about this idea of like the Lifetime movie special and what we think of as domestic violence, the Lifetime movie where a woman gets hit and it's very clear. And then that of course resolves easily, right? And there's no like housing or legal issues. But we know that's not the reality of domestic violence. We know that domestic violence isn't just physical. We know that it's emotional. It can be stalking. It can be sexual violence, financial abuse, and verbal abuse. And what I have heard from survivors over the years is that oftentimes it's the physical violence that was the thing that's been easiest to heal from. It's the emotional abuse and the way that a person is really objectified through the process of domestic violence that's lasting. And for the purposes of today, the other thing that we really see as lasting is financial abuse. Financial abuse and lack of finances or lack of access to finances, lack of control over a family's finances really leads to housing instability. We see that, you know, poverty and housing instability are two things you can't pull apart. Domestic violence and poverty and housing instability is a third. And so it's really important to look at this intersectionally and know that we can't work to end domestic violence without also working to end poverty, without also working to end homelessness, because it's all so interconnected. So from our friends at Safe Housing Partnerships, which Nash is a part of, 80% of a study done with homeless mothers found that they had previously experienced domestic violence, and 57% reported it as the direct cause of their homelessness. So when you are working with a family who has a female head of household, 80% of those folks will have experienced domestic violence at some point. So the vast majority of families that you work with have experienced domestic violence. 57% of those families would say that DV was the reason they became homeless. Again, I would say that that number is much higher because of how domestic violence is so underreported, particularly so underreported in communities of color, that it's really hard to believe that it is just half. I would anecdotally tell you that it is far more. So it's really important to focus on the solutions for survivors that lead to the other things other than homelessness. We don't want a survivor to have to become homeless to get their needs met. And when you enter into domestic violence shelter, you become homeless. It's not the best fit. The DV shelters are often full. I've spoken to many of you across the state. When you can't get a survivor into shelter, it's simply because there's no room. We know that we have to partner with folks in the community to make sure that long-term permanent housing options are available for survivors. While DV shelter can be a great fast solution, it is a necessary solution for many survivors. Having a affordable housing option is even better. As we stated before, economic abuse can impact the ability to obtain and maintain housing. And so really being able to work with survivors to find the most affordable option that will guarantee both their safety and their ability to move forward is essential. And so the partnerships that we have in the community with you all are the ones that are really keeping survivors safe and stable. And we're so grateful for them. When you're working with survivors, these are the 3 key components that we would suggest that you look toward. That's safety, confidentiality, and being trauma informed. And with that, I am going to turn it over to my friend Larissa to talk about federal and state housing protections.
Thanks so much, Maria. Hi, everyone. It's so great to be here today. So as Maria shared, we have a lot of content. We are also going to have some interactive scenarios, which we'll get to in a little bit. And Danny and I have co-presented this training before. And so we usually sort of work together in different parts. So you'll see some of that action as well. So for the federal overview, some of the content slides give you a lot of information. There's more information in the resources and materials that we flag at the end. But we're really going to give the high level broad strokes. So you all have this in mind. And some of this you may already know, which is a great starting point. So we're going to cover Federal Fair Housing Act, Violence Against Women Act, Americans with Disabilities Act, and Section 504 of the Rehabilitation Act, which is also connected to disability. Next slide, please. So the Federal Fair Housing Act, also known as FHA, protects domestic violence survivors from discrimination in housing situations. And what's key about FHA is that it applies whether the housing is supported financially by the government or not. And VAWA is more restrictive and limited there in terms of when it applies. So what's important to know about the Fair Housing Act is that it prohibits discrimination against survivors in essentially all housing, and the housing does not have to be supported by the government. Next slide, please. All right, so rights of survivors under FHA. So survivors have a right to be free from discrimination when seeking housing, to buy or rent. They're protected from eviction, be protected or be treated the same as other tenants or occupants by a housing provider. And they have the right to request a reasonable accommodation to ensure that someone with a disability has equal opportunity to use and enjoy the housing. Now we're going to jump into VAWA. So the Violence Against Women Act, which many of you I'm sure are familiar with, also known as VAWA, provides housing protections for survivors of domestic violence, sexual assault, dating violence, and stalking, just who are applying for or living in federally assisted housing. And I'm going to talk about what that looks like in a minute. Just want to flag here that many of you may also work with, or some of you may be thinking of, what about human trafficking survivors? While human trafficking is not a listed category here as protected, however, many human trafficking survivors will fall into one of these categories. And so if issues come up connected to housing, connected to someone who's a human trafficking survivor, that does not automatically mean that they are not protected by VAWA. Also, some states there are some state and local protections for human trafficking survivors as well. Although I'm not actually sure if that's the case in Pennsylvania. I want to be inclined to say not necessarily. Danny? Sort of. Okay.
Yeah.
Okay. So, okay. There might be some places. Okay, so just know that human trafficking survivors are on our mind too, and they are also protected in some of these ways, if that's something that's flagged. Okay, so VAWA applies to a survivor, whether they're an actual survivor or a perceived survivor, regardless of sex, gender identity, sexual orientation, disability, or age. VAWA does not apply to market rate rental housing, so private units. However, I just want to be really clear. When I say that, there's some point of confusion, so I want to be really, really clear. If there is a federal subsidy involved, a voucher, which includes funding through the continuums of care or emergency solutions grants, not just sort of what generally comes to mind as in like a Section 8 voucher or housing choice voucher, that applies. That applies, and that means that the tenants or program participants are protected and VAWA applies. So even if it is a private landlord, there is a federal subsidy connection and VAWA does apply. Okay, so survivors' rights. Survivors can't be denied admission, be evicted, or have their assistance terminated because of the violence committed against them. They must get a notice. And it's not just survivors, everyone all tenants and program participants at different points have to receive a notice regarding their housing rights and protections under the Violence Against Women Act. Survivors can request that an abuser be removed from a lease and housing. Survivors with housing choice vouchers, also known as Section 8, can move with continued assistance, and that actually applies for other mobile vouchers or subsidies. They have a right to seek an emergency transfer, which we'll talk about in depth a little bit later. They have a right to stay in the unit, even if there is or has been criminal activity, if that activity is connected to the violence. They have a right to strict confidentiality of information, and they can self-certify. We're going to get into this when we talk about documentation. They can self-certify using a HUD self-certification form. And we'll get into more detail when we get into the documentation section, because there's also some state laws that apply. All right, so what programs are covered? Who's covered? What does this look like? So here is the comprehensive list right now as of VAWA 2013, which still applies to date, of who's covered. So generally speaking, we're looking at public housing, Section 8, these other housing types. What's new with VAWA 2013, which is a couple of years old, and I think all of you are educated on this at this point, is that it also applies to organizations that are funded through McKinney-Vento. So we're talking about HUD, Continuums of Care, ESGs, and some other programs. That's really, really important because that expands the rights of survivors in those shelters and housing spaces, which is really, really key. The other piece that I also want to just flag is that VAWA also applies to the low-income housing tax credit. And that's another area that there's some really great training, really interesting partnership actually in Pennsylvania around. We're not going to dig into that here, but there's some great webinars that have been done and resources that are available. So I'm just going to put that out there. And if you all are like, what is this tax credit? Those webinars will give you insight into that as well. Okay. Next slide, please. Okay, so let's talk about the ADA briefly. So the Americans with Disabilities Act, survivors experiencing disabilities are entitled to protections under the ADA. It prohibits discrimination against individuals with disabilities in public accommodations. That means it applies to all shelters operated by the government and to private shelters. And then Section 504, as I said before, is also connected to disability. It provides discrimination protections for survivors with disabilities by housing providers that receive federal funding. And Section 504 outlines more areas than the ADA. There's some more flexibility and I think more protections. And so I always make sure that I include that in the training because it's just important to flag. If there is a survivor who you are working with or there are issues connected to disability, there are additional other protections that come into play that exist. So just important to flag that. And I think I'm passing it over to Danny now. So I'll mute myself. Danny, it's all yours.
Thanks, Larissa. Hello, everyone. As Maria stated, I am Danny Petio and I work for PCADV, and I'm very excited to be here. And I'm going to talk a bit about the Pennsylvania housing protections that are available. Larissa touched on the federal. We're going to talk a little bit about state here. So some states in Pennsylvania included have protections that mirror the federal housing protections. So they're going to look a little bit, they're going to look almost exactly like what Larissa just went over. And they may even go a bit further as they do in Pennsylvania, which we'll talk about in a second. However, Pennsylvania protections do not extend to all rental market housing. So they may be specific, as VAWA is, to public housing and government subsidized housing, or to only private housing. Next slide, please. So I'm just going to talk a bit about Act 200 of 2014. And Act 200 of 2014 prohibits municipalities from enacting what are called nuisance ordinances. So some of you may be familiar with nuisance ordinances, but nuisance ordinances are essentially ordinances that are meant to decrease crime and drug activity within a neighborhood and possibly blight, but they end up disproportionately impacting survivors of domestic violence. And the way that they do that is they penalize survivors for calling emergency services in a crisis. And the reason that we have this law is a case out of Norristown that some of you may be familiar with, which is Briggs versus the city of Norristown. And there, the landlord tried to evict the tenant because she had called the police after she was stabbed by her abuser. That case did not result in an opinion. It settled out of court. But one of the main things was the city of Norristown agreed to remove their nuisance ordinance. And and then shortly after that, we had Act 200. So I'm not going to get into the very specific details, but Act 200 prohibits municipalities from enacting nuisance ordinances that would penalize survivors or any individual who's calling for police or emergency assistance. And this covers all rental properties, including private. So, and it also protects the resident tenant or the landlord. So the landlord typically in these scenarios is forced to evict an individual because of what is discovered in the unit, or because they contacted emergency services. Act 200 would prohibit municipalities from requiring landlords to do that. Next slide, please. So this is just a little bit more about Act 200, and this is specifically the remedies that are available. If the municipality enforces or attempts to enforce a nuisance ordinance. So they will be required to cease and desist that action. They may have to pay compensatory damages, provided that the individual who is petitioning the court makes a reasonable effort to mitigate those damages. They may be responsible for attorney's fees, court costs, and other equitable relief. So bottom line, it's very risky for municipalities to enact ordinances that could potentially penalize survivors, both constitutionally and also monetarily. And we've seen municipalities have to pay out six-figure or more settlements due to these ordinances being struck down. Next slide. So Larissa went over a bit about the Fair Housing Act, and what I want to talk about is the Pennsylvania equivalent, which is the Pennsylvania Human Relations Act, or the PHRA. So what's important to know is the PHRA includes all the protected classes that already exist under the Fair Housing Act. So sex, color, national origin, ethnic background, religious affiliation, etc. It also expands upon the protected classes by including two more, which is any person who uses a guide or support animal because of blindness, of deafness, or living with a physical handicap, or someone who's a handler or trainer of support or guide animals. So it just expands, as I said in the beginning, a bit on what is already existing under federal law. What's important is Pennsylvania law does not include sexual orientation and gender identity. However, the current administration has been interpreting that similarly along the lines as federal law was interpreting prior to the recent Supreme Court case that opened up suit for discrimination under these identity grounds. And it essentially lumps it in under the gender and sex discrimination because it is preferences on how individuals identify per the gender that they want to identify. So while it is not specifically outlined in the law, individuals still may have a cause of action and may be entitled to relief if they are discriminated on the basis of their sexual orientation and gender identity under Pennsylvania law. And as Larissa said, and Maria talked about, it's very important to look at the intersectionality of sort of the oppressions that your survivor is dealing with, because they could be honestly discriminated under many of the categories and protected classes under both the PHRA and Fair Housing Act. So where they may not have a cause for relief, you need to look at the entire situation because they may have an avenue under another protected class that they belong to or they identify as. So this is just a list of what the PHRA prohibits, and it's attempting or evicting individuals due to pregnancy or birth, discrimination based on the guide or support animal, refusal to rent because the individual has a known relationship or association with an individual who lives with a handicap or disability. Again, like the Fair Housing Act, refusal to permit reasonable modifications, refusal to make reasonable rules, policies, practice, and services. And also to, this is really important for survivors, but this is as they, it is prohibited for individuals and housing authorities to ask for or elicit any information regarding that individual status in that protected class. And that typically could involve confidential or sensitive information about the survivor's victimization, as that would qualify them for a protected class based on gender or any other specific protected class. Next slide, please. So this is very important. PHRA prohibits retaliatory eviction. So retaliatory eviction, the main ones that the PHRA prohibits is when tenants assert their legal rights, and they include if the tenant participates in a tenant association or assembling a tenant unit due to mass evictions and issues surrounding evictions with COVID-19. This is a very of the moment sort of issue that tenants are forming tenant associations and unions. Under Pennsylvania law, you cannot evict an individual for doing that. You cannot evict them for filing a complaint with a government agency about their unsafe or illegal living conditions. And you can't evict them for going to court and trying to exercise any of their state and local laws. So retaliatory, so tenants do have and survivors do have that extra security under the PHRA that they will not face retaliatory evictions for doing any of these things. And if they do, they have a cause for relief under this form of law. Next slide, please. So I do want to talk a bit about the Protection from Abuse Act, which is our bread and butter at PCADB, and we talk about often. So the Protection from Abuse Act includes a section which is called exclusive possession, which is just a fancy term for evicting the defendant from the residence. So there are a couple of qualifiers that get a little bit confusing under the Protection from Abuse Act that allow a petitioner to take advantage of this exclusive possession section. So when you're looking at the property, the parties must either solely own it, so your petitioner must own it in their name alone, or lease it in their name alone. If they do not, they must own it or lease it jointly. It says through entireties here, which is a fancy name for marriage. Okay, so they either lease it jointly or they are a married couple and they own it through marriage. Now, if you have the defendant who is the only listed person on a deed or a lease, you could still get exclusive possession or ask for it if it is one, marital property, or if your defendant has a duty to support the plaintiff. What does a duty to support mean? They're either married, so there's a spousal support duty, or they have children in common, or there's a child support duty. That's all that means. So that's just a small little qualifier to go through to see if the survivor would be able to ask for this. Again, the landlord cannot participate in retaliatory eviction, both under the PHRA Act and also under the Protection from Abuse Act if they are granted exclusive possession. So that cannot happen. And there is no lease bifurcation under PA law. However, there is nothing under PA law prohibiting a landlord from bifurcating a lease if a survivor voluntarily asks for that. And we encourage this a lot. And one of the main things that, Maria has always told me is to really say to the landlord that it's going to be to the landlord's benefit to evict the abuser, to make it simple. They're usually the source for the damages, the source for unpaid or back fees, and other lease violations going on the property. There is really no issue with doing this. All that this landlord needs to do is write up a new lease. That just includes the survivor removing the abuser from that lease. Next slide. And under PA landlord tenant law, we do not have anything that prohibits, that allows for lockouts in domestic violence cases, unfortunately. Under Pennsylvania law, a lockout is what we consider a self-help eviction, which means that you change the locks without the tenant's permission. Bottom line, if you're a landlord or anybody who has the power to do this, don't. Because it does not end well in Pennsylvania. So without a court order, you can't change the locks, and you can't threaten to change the locks as well. Also, you can't refuse to make necessary repairs to the unit. And we're really talking about habitability, things that require the tenant to live comfortably and safely in the unit: heat, hot water, electricity, broken windows, anything like that. Or shutting off utilities or other actions that have made the home unlivable so the tenant moves out. So you can't lock them out, and you can't force them to leave either. This would be considered a self-help eviction. So if you have a survivor that is a victim of a self-help eviction, not only could the landlord be forced to correct that legal procedure and follow the correct one, but landlords, beware, because you could be responsible for punitive damages as well. So self-help evictions without that court approval are extremely, extremely risky. Next slide. And I just want to touch on something that is extremely, extremely new as of, I believe, 13 days or 14 days new as of right now. But on January 21st of 2021, new minor court rules went into effect in Pennsylvania, and they provide for a 30-day stay of execution on an order of possession and a 30-day extension of the eviction appeal period for survivors of domestic violence. All that needs to be done is that when the survivor gets the judgment from the lower court, they just need to file a notice of appeal, the copy of the judgment, and a new domestic violence affidavit. And that will stay the eviction for 30 days and extends that appeals period for 30 days, which is a very large reprieve for survivors, to be perfectly honest, and has not been available for survivors under PA law ever before. The affidavit, as of the last, I have not checked very recently, but it should be available on the AOPC's website. We had done some research into this rule before it came into effect, and it had not been up on the website, but the rule states that it will be a form created by the administrative office, and that you do not need to draft, or nor does the survivor need to draft their own form. And finally, a domestic violence victim defined under the law is anybody who's had a protection from abuse order or could provide other evidence of abuse. Typically, my advice in that is that seems to skew a bit broad. And if you could provide any evidence of victimization and domestic violence besides a PFA order, that should be accepted as well. But I believe at this time, it's going to go back to Larissa.
Thanks, Danny. All right, so we're going to spend a little time just focusing on discrimination, and that's where we're going to have you all, hopefully you have your phones available because you're going to be sending a text and we're going to be doing a poll. All right, so let's dive in. All right, so as a refresher, the laws that apply in terms of discrimination, we have VAWA, federal fair housing, all of the different state statutes listed here that Danny just went over very thoroughly, but they're noted here as well. And just a refresher, so these protections for survivors mean that survivors are protected against being denied admission, housing, being evicted, having assistance terminated because of the violence committed against them. All right. Oh, you know what? Just saw a typo, which we added in, and it says in private market, but actually that should be refined some. So just to note here, we're really talking about federally subsidized housing. There's very minor things that Danny just went through and can talk about further offline that might connect to private landlords. Okay, just wanted to flag that so that there was no confusion. All right, let's keep rolling. Thanks, Maria. Okay, so we're gonna do a poll. This is going to be the first of our polls. I don't know if anyone has done poll everywhere before. It looks pretty easy. We'll find out. So here's what you all will do. We're going to put up the scenario. In the scenario, there's going to be a question. We're going to provide you all with the text information to text. I've activated the poll already, and you're going to just put in your response. And so we're going to get a sense of what you all are gathering, what you all know, what you all are digesting in terms of what we're sharing with you around the protections for survivors. So it should be pretty straightforward. We're going to try it. If it works, great. If it doesn't, we're going to go another route. All right, let's roll. I think we're going into, all right, poll question and poll scenario 1. Okay. A match was made for a survivor of domestic violence to our program. We don't accept survivors because they should be referred to the DV system. So we're talking about a homeless or housing program that is probably general population, maybe adults or families, and they're saying that they don't accept survivors. There's a domestic violence system. The survivor should go there. If we were to accept the survivor, we'd require the survivor to have a protection order or counseling and to no longer be with the perpetrator. So the question is this decision by a program to not accept domestic violence survivors discriminatory? So here's the instructions for you all. You have to send a text. It's apparently when you set up an account, it's the full name. So Larissa Kaufman 027 and 2233 to join the session. And then you put in A, B, or C for your response. So yes, the decision is discriminatory. No, it's not discriminatory, or maybe it is, or maybe I'm not totally sure, but it could go either way. So while the screen is up, I'm going to go to our session with the question, and I'm going to give you all a minute to see how this works. And if it works, and give it a second to get going. Oh, responses are coming in. It works. All right, everyone, get your phones going. Let's see where you are with this. What do you think? Is the decision discriminatory? I mean, it's like I'm entering a world of being a technology enthusiast, and it's not like we have a lot to thank the pandemic for, but I guess that's something. So now we're using poll everywhere as a way to hear from everyone. All right, another 30 seconds before we close it out. All right, so it looks like the majority of you are saying, yes, this is discriminatory. So let's look at the answer. And I'll take away the veil of surprise. Yeah, it is discriminatory. So a program can't deny housing to an individual or family due to actual or perceived status, due to an actual or perceived status of domestic violence. And that also applies to dating violence, sexual assault, and stalking, right? Violence Against Women Act applies here, and there are other protections too. So a program can't ask a survivor to do something that they wouldn't require other potential participants to do. And for those of you who are really nerdy, or there might be some lawyers out there, yes, you have to treat all participants similarly, federal fair housing and state fair housing. So the deal is that there are multiple protections. You can't ask for additional documentation and steps to be taken, and you cannot turn survivors away. Okay, next slide. Okay, so here we go. Another poll question. Let's do it again now that we're really getting into it. Okay, so a survivor is looking for an apartment where a Section 8 voucher is accepted. She applies but gets rejected. She says she overheard one of the people who lives in the same apartment complex tell the manager that the survivor's current supervisor is stalking her, coming to her former apartment, yelling and threatening her. The survivor thinks this is the reason why she didn't get the apartment. Question: is the landlord's denial of housing discriminatory? All right, I just activated the second poll. So the question is the landlord's denial, based on what the survivor thinks the reason is, discriminatory? So take a moment, same instructions apply, send the text to Larissa Kaufman 027 22333. They're in the session. A, B, I feel like Fiona White, A, B, or C. Yes, no, or maybe. All right, let's take a look. Okay, y'all are so good. Have you taken our training before, other training around this? That's another poll question I should ask. Okay, so we're coming in at maybe. The majority is with maybe, and that's right. Maybe. Trick question, everyone. It might be. So if the housing manager denies an applicant an apartment because the applicant or the survivor is experiencing stalking, or because the landlord thinks the applicant is being stalked, yes, it's discriminatory. So as advocates and those that need to know, more digging needs to happen here. Okay, more digging needs to happen, and more digging can happen to find out the reason why. It might be a little bit more veiled, but that's why it's a maybe. Okay, next slide, please. We're in documentation. I think I'm starting us off with the federal, and then we're going to go to Danny. I'm going to keep this relatively short because there's a very key takeaway, and I love saying this to everyone out there. The big takeaway when it comes to documentation, and this is where things get confusing, and sometimes it's confusing, frankly, because there are actually policies in place that are not in compliance with federal law. Okay, so the deal is that housing providers don't have to ask for documentation. So if a survivor is asking for an emergency transfer, lease bifurcation, whatever the case may be, and invoking Violence Against Women Act or state protections, okay, then the housing provider doesn't, some state protections, the housing provider, and Danny, I'll get into it. Some housing providers don't have to ask for proof, okay? They don't have to. They can move forward with the process. However, we know that oftentimes that's not the case. Here's where things get a little dicey. At the end of the day, the survivor gets to determine which form of documentation to provide and is only supposed to provide one form of documentation. Housing provider can't say, hey, I need a police report from you, and I also need a letter from an advocate. They can't say that. They don't get to decide. The survivor decides. And at the survivor's fingertips in 15 different languages is something called a self-certification form, where the survivor can fill that out and they can put in the information, and that can be enough. Okay, this is the vast majority of the cases. One form of documentation, many different options of what the survivor can provide for documentation. Survivor decides. Okay, those are the takeaways. Everything else y'all can read on the slide. Okay, 14 business days from the request, yada, yada. Okay, let's keep going. Now, full list of the types of documentation that the survivor can choose from. VAWA self-certification form. We'll have a link to that in, towards the end of our training. Police court or administrative orders or protection order, police report, statement from a third party. Yes, victim service providers and others can write a letter. It can be very simple, very, very standard, without a lot of information that is enough to qualify for documentation in this case. Okay, and then on the side, statements or other evidence, let's keep that narrow. The most common are the three that I just went through. Okay, next slide, please. And I said this again, everyone, the takeaway from Larissa's part here, Survivor gets to pick. It's one form of documentation. We listed them out. They can self-certify. They can get that qualified third party. So a police report, protection order, letter from an advocate, letter from a medical professional, etc. Okay, one form of documentation, survivor picks. Very few exceptions. This might apply sometimes, but I want to just say this, it's very clear. The only time this applies, this exception, is if there's conflicting information shared, which sometimes happens. So sometimes you might have a perpetrator who's claiming to be the victim and they're providing information. Then it gets confusing. Okay, like who do I support? Okay, at that point, a housing provider can ask for third-party documentation. From the documentation that I just covered, third-party documentation is essentially anything other than that self-certification form. Okay, so survivor can provide one of those other forms of documentation. What's really key here is that housing providers are not, and the law is not set up for housing providers to be the police, the jury, and everyone else, all right? This is to give you all some more information. At the end of the day, what's really important is survivor safety, period. And so we move in that direction. So it's not extending it because now we need 500 forms of documentation. It's moving in that direction if there's an issue, and also working with PCADV, local programs to get some support for yourself and also for the survivor around how to navigate. Okay, there are folks out there to help. Okay, next slide, please. I think we're going to move it over to Danny in a second. Danny, this is you. You're taking it over.
This is me. So
Okay.
thank you, Larissa. So again, we have we have federal law codified into state law. So the state law equivalent of the VAWA 2013 guidance and protections is Act 148 of 2018. So instead of what the law refers to it as is documentation of sufficient proof. And it is sufficient proof of domestic or sexual violence. So what is considered sufficient proof and documentation? It's either a copy of a current PFA, similarly to VAWA, it's police reports, medical records, court documents. We will talk in a second about the certification of abuse, which is very much like the VAWA self-certification form, and then any other evidence of a conviction or adjudication of guilt. So that opens it up to a bit more than just criminal court. We're talking about any adjudication of guilt, which includes findings of abuse in protection order cases as well. However, this is a bit different than VAWA in that this information is required pretty much upfront in regards to determining that the individual is a victim of domestic or sexual violence. Next slide. So the certification of abuse, what is that? It is outlined right in the statute of exactly what it is. It's very much like the self-certification form for VAWA. And this must include this specific information listed here, which is the tenant's name, the address of the tenant's unit, the statement that the individual is an affiliated victim, is an unaffiliated individual or victim of domestic or sexual violence. If safe and known, the name of the perpetrator, you may know it, it may not be safe to provide. Please be mindful of that. Just knowing the name does not mean it's automatically safe to provide that information to the housing providers. Like Larissa said, similar to VAWA Act 148 has strict confidentiality requirements that housing providers are beholden to in making these determinations and soliciting this information. But this is my advice that if there is a safety concern, when in doubt, it's best to not provide the information unless specifically requested or ordered to. And the proposed termination for the lease or the release of the tenant from the lease. So this is what this is what the certification needs to contain. Again, like VAWA in the previous slide, the survivor is the one who chooses the form of documentation. So they could provide a copy of their PFA, or they could provide a certification of abuse. They're the one who decides, and they only need to provide one. Next slide. Just like VAWA, the housing authority can also ask for a written verification if that third party presents conflicting evidence. So again, you have an abuser who says, I'm the victim, there is a conflicting testimony, whatever it may be, between the parties. If that conflicting evidence is offered, then the housing authority can ask for this written verification. Keyword being can. They don't have to ask for this. And if they do, this is again the information that the tenant needs to provide: their name, their dwelling unit, the approximate date of the incident, and including the most recent date, the name, address, and telephone number of the attesting third party. So the authority may waive inclusion of any part of this information if it determines that there's a risk of safety to the tenant or that an affiliated individual. So again, they don't always have to ask for this information, and the survivor is not obligated to provide for it. Again, if there's a safety risk, you don't need this information, and it's better to uphold the safety of the survivor and their family as opposed to request more information that could possibly be necessary at that specific time. Also, the attesting third party just states the capacity in which they are aware of the client's victimization and that statement. Next slide. So the attesting third party, again, this information is only provided if the housing authority asks for it and the other person provides conflicting information. So the attesting third party is going to state in that statement that they've been advised that the tenant is a victim. They find that consideration credible. They understand that the verification could be used as a basis for releasing the tenant from the lease. And they understand that the statement is discoverable, can be used in court proceedings. So who is an attesting third party? This is very easy. It's really anybody who comes to find out about the victimization in the course of their work with the survivor. So law enforcement, police, anybody, any law enforcement official that the survivor comes in contact who has knowledge of their victimization. Licensed healthcare professional, that could be a medical doctor, it could also be a mental health professional as well. Those are both licensed healthcare professionals. That is a broader qualification. Victim advocate, which would be someone who works at one of our local programs, or victim service provider. That is also included as a separate term, but I would include them as similar attesting third parties, excuse me, and a victim assistant, which is specifically an individual who works on behalf of the county and the DA's office, who may be aware of the individual's victimization through a criminal case. Next slide. All right, so this—
Hey, Danny, I know you want to do it. I want to jump in. I think we have 5 minutes left and it's just flying. So I'm going to make a recommendation. Because I feel like we need to talk about transfers.
Yeah, no, that's totally fine.
I hate to nix it, y'all. The poll's exciting. Do it on your own time. But I think we got to get to transfer so you all have an overview of something more concrete that I know comes up a lot. Are you good with that? And then Danny, it's you and Maria. So, okay. All right. Love that poll though. Love that poll.
Okay, sorry, this is me. So in Pennsylvania, we have worked diligently over the last year or so to make sure that we have emergency transfers in place in the balance of state continuums of care. Emergency transfers have been talked a lot about with public housing authorities, but what we've done is strategically place the emergency transfer policy at the COC level, so it sort of covers everyone, including PHAs. We know that people move from housing type to housing type, and we don't want that to disturb what a survivor actually needs. So when an emergency transfer request comes up, it really is so similar to what Danny and Larissa have already spoken about, that it is not on the onus of the survivor to prove that a thing is happening. What it's about is making sure a survivor is safe. I understand that many times when a document is put in front of a housing provider or a landlord or whomever, it is our sort of idea that we need to fill out that document entirely and make sure that all our I's are dotted and T's are crossed and this sort of thing. What I'm here to tell you is the most important thing is survivor safety. And so if you need to move a survivor quickly and then figure out the paperwork later, please do that. There is no COC in the state where that's going to get you in trouble. And PCADV has partnered very closely with the COCs to make sure that that happens. So there needs to be reasonable belief that an issue has occurred and the participant needs to request the transfer. And what this means is that a landlord can't say, I think something happened, and so I'm going to transfer you. So all of this is done because a survivor has said, I need an option. And you as a housing provider or landlord or whomever has said, here is a good option for you. Tell me what you think. Really, really important. Call me at PCADV. I will walk you through the entire process. Call the consultants at the COC level. Call whomever. Like, don't think you need to do this alone. Also, we're all here to. Am I muted? Sorry. So we want to prioritize internal transfers first. You need a policy in place on how to assist specifically, and that exists at the COC level. So you can use the COC policy, you can lean on that. You can also create a policy on your own in your own organization. It just needs to not be in conflict with the COC policy. That policy has been voted on by the COC boards in the balance of state. So you also need to make sure that an external transfer would be available if necessary, but you really want to make, if you can do an internal transfer within your program first, that's the best way to do it. The policy needs to make sure it describes how to move tenant-based rental assistance. We do that through the coordinated entry system. There's a process in place. Again, one of the more important pieces of this is that none of this is recorded in HMIS. So again, like keeping paper documents and keeping a file is really the best way to go. And knowing that like you're doing something that is legal and allowed and encouraged by VAWA, and VAWA covers HUD, and you're not going to get in trouble. Like this is a necessary thing. And what I hear from landlords over and over and over again is that oftentimes you want to keep the peace in your building. This is the way to do it. This is the way to do it. So do this, do right by survivors, and don't worry that something else is going to happen over here. And if you are worried, please call me. That's what this slide should have just said, is please call me. Sorry, I'm just kidding. So this also can impact family members that live with the survivor. It doesn't have to be people, children or dependents of the survivor. It can be other people that live in the unit. Oftentimes domestic violence can affect an entire unit of people, so we want to make sure that they're all assisted and taken care of. And you can end the lease without penalty if needed, but they do have to be eligible for whatever resource they're moving into. So that's an important piece of it. Eligibility requirements are the same though across. And if a survivor requests it, it needs to be available. You can also use COC grant funds to pay for damages and that sort of thing. That is very complex. And if you need assistance with that, the consultants and myself can certainly help. Danny, this is you, my friend.
Yeah, so this is almost exactly the same as what Maria just covered. So under Act 48, emergency transfers are called relocations. The Act 48 allows the same right for a survivor to request a relocation due to domestic or sexual violence, requires the similar 90-day requirement to having when to have experienced the violence on or near the premises. And again, also includes that same standard that the tenant reasonably believes there's a risk of imminent harm if they're to remain on the property. Next slide. And again, this is very similar to the requirements under VAWA. PHA needs to make a good faith effort to reasonably relocate the tenant to safe, suitable dwelling under their control or the control of another authority. And there's also, they have the ability to request not just the emergency transfer from one dwelling unit to another under the authority. They can receive a housing choice voucher. they could ask the PHA to assist with identifying other housing providers that have safe and available dwelling units, or they could also assist with contacting local victim service providers like our programs that could aid with with providing assistance to the survivor.
Okay, and
And
that is our time.
yeah.
So these are some resources that we covered within the presentation on both the slide and the next, this HUD certification form. I know that many of you do have that. Most importantly, and this is the example of the emergency transfer plan for the ECOC. This is our contact information. If you need anything, please reach out to any and all of us. All of us provide technical assistance in Pennsylvania, and Larissa provides it nationally. And so anything that you need, please do feel free to reach out. And we're really grateful that we got to share this time with you today. Thank you all very much.
Thank you.
Thank you.